The genius of the U.S. Constitution is in its clarity. Nowhere is this more evident than in the Bill of Rights. 10 short amendments written in plain language, designed to protect individual liberty and limit the power of government. Yet, over the course of more than 2 centuries, we've increasingly witnessed a judicial tendency to treat this foundational document not as law, but as a suggestion to be shaped, bent, or bypassed to abide the preferences of judges. The problem is not just that courts reinterpret the Constitution, it's that they do so in direct contradiction to the plain language of the text. They create exceptions where none exist. They use vague principles like reasonableness, public interest, or compelling state interest to override explicit prohibitions. In doing so, they substitute judicial authority for constitutional integrity. Take the Fourth Amendment. It does not say the government may search your home or seize your property. If a judge thinks it's reasonable, or if the purpose is noble, it says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. The language is clear. It draws a bright line. No warrants without probable cause, no searches or seizures that are unreasonable. But over the decades, that clarity has been diluted by judicial invention. Courts have declared that warrantless searches are acceptable at airports, borders, sobriety checkpoints, and even school lockers. None of these exceptions are found in the text. Each was invented by judges who decided that their ends justify ignoring constitutional principles. This raises an uncomfortable but essential question. If courts can carve out exceptions to the Constitution whenever they see fit, then what is the point of having a Constitution at all? After all, a contract that means whatever one party decides it should mean is not a contract, it's a blank check. The First Amendment says, Congress shall make no law abridging the freedom of speech. Not some laws, not reasonable laws, but no law. Yet over time we have seen speech regulated, censored, and punished under a growing list of judicial exceptions like fighting words, hate speech, or incitement. None of those exceptions were derived from the text. They are derived from judicial philosophy, from the assumption that courts must be pragmatic rather than principled. But pragmatism at the expense of principle is precisely how liberty dies, even when they occur as small compromises cloaked in high-minded rhetoric. What's even more disturbing is the selective nature of these exceptions. The right to keep and bear arms, the right to be free from warrantless searches, and the right to due process are increasingly treated as conditional, dependent on a judge's mood or ideology. The founders did not entrust courts with the power to rewrite the Constitution. They gave that power to the people through Article 5, the amendment process. It is a deliberately difficult process, requiring broad consensus. Changing the fundamental rules of the Republic was not meant to be easy. Judges bypass this process because it enhances their power. Why wait for the people to approve a constitutional amendment when 5 justices can impose the same outcome by judicial fiat? Some will argue that courts must adapt the Constitution to modern conditions. We must have a living Constitution, they say. However, the Constitution is a contract between the government and the people. If one party alters the contract, it is essentially invalidated. The Constitution already contains within it the tools for change, amendments, legislation, and federalism. It does not authorize mutations disguised as interpretation. When judges are allowed to invent exceptions, the rule of law morphs into the rule of men. Rights become privileges which can be revoked. Today, it's the TSA rummaging through your luggage. Tomorrow, it's the government deciding whether your speech is harmful or whether your business practices are socially responsible enough to deserve protection. The question is not whether exceptions are sometimes useful. The question is who gets to decide. If judges can ignore clear constitutional commands whenever they believe the situation warrants it, then we no longer live under a written constitution. We live in accord with the values of 9 unelected individuals. That is an oligarchy, not a republic. The Constitution was designed to limit the power of government, and that includes the judiciary. When courts take it upon themselves to rewrite our founding document to meet their own preferences, they become precisely the threat the founders sought to restrain. The words of the Constitution are not placeholders. They are not starting points for philosophical inquiry. They are law, binding law. If they are to mean anything, they must be obeyed as written, not reimagined to be what politicians in robes would have preferred.
Can you say why America is the greatest country in the world?
Freedom and freedom. So let's keep it that way.
Well, I think it's time we ask ourselves if we still know the freedoms that were intended for us by the Founding Fathers.
Everything in the Bill of Rights tells the government what it can't do to restrict my freedom.
Make government more the servant and not the master of us all. In this free nation, we do not choose to be ruled. We elect to be governed.
Do not support your own oppressors. Stop letting the system exploit you.
I think that the real job that we have that confronts us is to somehow be able to sell our fellow Americans on the moral superiority of personal liberty.
I would remind you that extremism in the defense of liberty is no vice.